Good afternoon, everyone. It's 12:30, so we will make a start. We are delighted to be presenting this webinar on the new NEC4 suite, which was published on the 22nd of June 2016 to the CIHT East of England members, plus a few of our own clients and contacts. Our focus today is on the Professional Services Contract, or the PSC, and the Engineering and Construction Contract, or ECC, the two main forms of the NEC suite. But we'll also touch on some of the other contracts in the suite, including the Term Services Contract. The session will last approximately an hour. Do feel free to send us your questions through the interactive box provided on the screen. We'll try to answer them either throughout the seminar or at the end, and if we don't have time, we will contact you direct afterwards. We are recording the webinar and will circulate this along with a copy of the slides to you all afterwards. Just bear with us as this takes a little time to get the recording ready, but it should be with you within the next 48 hours. It can then be shared with any members that aren't able to listen today. So starting with some brief introductions. My name is Buckby and I lead the Projects and Contracts Advisory Team at Beale & Company. I'm a member of the CIHT. I'm joined by my partner, James Vernon. James works in the Construction Dispute Resolution Team at Beale & Company. We are both lawyers who specialise in construction, engineering and infrastructure matters, and we feel we have a particular expertise in transportation projects. A bit more on who we are. Beale & Company is a specialist construction law firm. We've got offices in the UK, Ireland and the UAE. We're ranked as a leading firm in the legal directories of law firms in the fields of construction, engineering, technology and insurance. We've advised on some of the most significant highways and rail projects in the UK, including recently the M25 DBFO PFI, Crossrail, HS2 amongst others. As I said, a large part of our work relates to transportation matters. We are proud supporters of CIHT, being a member of CIHT's corporate partner scheme, and we also regularly contribute to Transportation Professional. And as I said, we are delighted to be talking to the CIHT East of England members today. In the next hour or so, the plan is to cover the topics on the slide, and in particular, the key changes to the PSC and the ECC, and we will provide our views on the same. This will be broken down into a brief refresher on the NEC, some of the general changes introduced by the new NEC4 suite, and then I'm going to look at the changes to the Professional Services Contract. James, he's going to look at the Engineering and Construction Contract. As an introductory comment, the more we read the new forms, the more comments or views we have, good or bad. I suppose what I mean by this is that it's obviously early days at the moment, so over the coming months there'll be further views made and positions taken, which will obviously be worth considering, and we are sending out various updates the more we use these forms. Right, so let's start with a quick refresher on the NEC forms. So a recap on NEC. It's our view that the NEC forms are the most common standard forms for construction and infrastructure projects. First published in '93 and last updated in April 2013, the NEC suite includes a number of different forms and has been promoted in the public sector by its use on significant projects, including most recently Crossrail and HS2. There's some others listed on the slide. The NEC's philosophy I suppose, can be summarised by the aim that their contracts promote effective and proactive management of construction projects. The forms are effectively, and the NEC is proud of this, project management and risk management tools. And it's important to note this, and James and I will keep coming back to these comments throughout the talk. Importantly, the philosophy can still be seen in the NEC4 suite. It's worth noting that NEC4 has effectively been endorsed by Highways England. Very recently, HE has announced that its new Regional Development Partnership, or RDP, which will, I think, replace the CDF, this will be based on the NEC4 suite. Practical collaboration and innovation will be encouraged under the RDP, and in my view, this therefore sits quite nicely with the NEC suite for the reasons James and I will discuss. So for those who will be getting involved in the RDP, this webinar is clearly of relevance to you. The tagline for the new NEC4 suite is evolution and not revolution. And there were three key objectives in drafting NEC4. At the first, providing greater stimulus for good project management. There's that word again. The second, providing support for new approaches to procurement, which improve contract management. And thirdly, inspiring, which is a powerful word, the increased use of NEC in new markets and sectors. Another aim of the amendments is to reduce the number of Z clauses being added to the suite, which unfortunately has been common practice. This is obviously a positive step, but sadly, and I would say this because I'm a lawyer, I do think Z clauses are here to stay. So the new NEC4 suite, what's in it? There are now 16 contracts in the suite, as detailed on this slide. This includes four new forms, as well as historic forms such as the ECC, the PSC, the Term Service Contract, the Framework Agreement, etc. NEC4 now includes the new Term Services and Professional Services subcontracts, as well as a new design, build and operate contract, and interestingly a consultation version of an NEC Alliance contract. So the new forms. The consultation version of the Alliance contract is much awaited, having been in the pipeline for many years. It effectively reflects the increased use of alliancing in the UK, particularly by Network Rail and the water companies as part of their AMP cycles. The consultation version is largely based on the Australian form of alliancing, which has been adopted in the UK by Network Rail in a number of large schemes. The contract is to be entered into by all the key parties on the project, so the designers, contractors and the client. It reflects a number of the key NEC3 principles, but as is common with alliancing contracts, includes no formal dispute resolution mechanism. For some, this might be strange, but this reflects the no blame, no claim culture typically adopted on alliancing projects, where all disputes are to be resolved by the Alliance Board. Consultation closed on the 30th of November last year, and NEC are now looking at the consultation feedback from users. The final version of the NEC4 Alliance contract is due to be published later this year. So moving on to the DBO contract, this is intended to allow the client to procure design, construction, operation and maintenance from one single contractor. In my view, it reflects NEC seeking to move into new markets, the EPC and the process plant market, where use of forms such as the ICME is much more common. And finally, the PSC and TSC subcontracts. These have been produced quite clearly to fill a gap in the NEC suite. As with the ECC subcontract, the PSC and TSC subcontracts include similar provisions to the relevant main contract form, but with buffers included in some of the time periods. NEC claim that these subcontract forms can be used with any NEC4 main contract. Just a word of warning, I think these forms do have their limitations. Firstly, the subcontracts do not include a typical obligation to comply with the main contract, as you would expect in any subcontract agreement. So, I therefore think the use of these forms with any different NEC4 contract is potentially a risk. And even if they were used under the relevant main contract form, I think they need to be amended carefully. I'm now going to hand you over to James, who is going to go into a bit more detail in relation to the general changes included in the NEC4 forms.
Thanks, Will. As Will says, I'm going to get into the changes that are seen across the NEC4 suite. The basic structure of the NEC4 contracts has not changed, with each contract made up of the core clauses, a main option, secondary options, which are W, X and Y, a schedule of cost components, the contract data, and if needed, any Z clauses. The key clauses under NEC4 have the same general effect as under the NEC3. The underlying principles have not fundamentally changed. Evolution, not revolution. In relation to the structure, the changes which have been made include the introduction of new clauses and secondary option clauses to reflect market practice, tweaks to the existing NEC3 position, and general changes to the terminology for consistency across the suite. So looking at the new provisions, these apply across the main forms, and the first is the obligation not to do a corrupt act, which also applies to a subcontractor. This is a ground for termination, and obviously reflects the Bribery Act 2010. Both parties now have a right to assign, which is unlimited other than that the client cannot assign to a party who does not agree to act in the spirit of mutual trust and cooperation. However, we consider this is likely to be amended in practice. The NEC4 also includes a new process for a final assessment to be made following the issue of the defect certificate or a termination certificate. This reflects the JCT approach to a final account. Under the PSC, the assessment is made by the service manager, and under the ECC, it is carried out by the project manager. If the assessment is not carried out, then the consultant or contractor can issue their own assessment, following which the final payment becomes due, other than following termination, and is conclusive evidence of the final amount due unless referred to the senior representatives or adjudicator within 4 weeks of the assessment being issued. The NEC4 construction contracts, as opposed to the professional appointments, also include a new secondary option X22 for early contractor involvement. This includes a two-stage process for the contractor to be appointed and reflects a general trend in the industry towards two-stage tendering. Another new secondary option in the construction contracts is X21, called whole life costs. This is perhaps misleading, as it is essentially a value engineering mechanism and not an obligation to minimise whole of life costs, which we see in, say, some network rail contracts. Although these provisions are not in the PSC, Consultants who are appointed by a contractor when X21 and or X22 is included can expect requests for assistance, which will need to be reflected in the consultant's appointment. In my view, these changes are not significant or may not come as a surprise. They are not something to write home about. As a firm, Beale & Company has played a significant role in the development of standard form wording for the use of BIM, and so we are particularly interested in the new BIM secondary option, option X10. This option reflects the NEC's aim to embrace the digital changes that are happening in the construction industry, which will be central in creating a step change in performance. This may be setting the bar slightly high, but the inclusion of X10 is a positive step. It is the first attempt in a standard contract suite to properly address BIM, other than simply referring to any BIM protocol. Option X10 refers to two main documents, the Information Execution Plan and the Information Model Requirements, which are in the scope. And these tie in with the two key documents required under PAS 1192/2, which are the BIM Execution Plan and the Employer's Information Requirements. Please note that if option X10 is used, the information model and the rights in any information used to create or change the information model will be owned by the client unless the information model requirements say otherwise. This is a commercial risk. In addition, if clause X9 transfer of rights does not apply, ownership of the rights in other documents will not transfer to the client. So this could result in a position where the intellectual property rights in some documents is retained by the consultant, but ownership of the BIM-related information transfers to the client. This is unhelpful drafting. However, overall we can welcome the changes in relation to BIM, but we must be careful with the intellectual property position, and that should be handled with care. Turning now to the general tweaks to the NEC3 position. First to look at is in relation to programme. If the service manager under the PSC or the project manager under the ECC does not reply to a programme within 2 weeks, and the failure continues for 1 week following a notice from the consultant or contractor, the programme is treated as accepted. Secondly, in relation to programming, if there is no programme referred to in the contract data, 25% of sums due can be retained under the ECC and PSC until the first programme is submitted. This will need to be managed and is a real example of the NEC promoting good project management, although the consequences are significant. The payment mechanism has changed in NEC4. The client now has a right to be paid if the amount due reduces. In addition, if no application for payment is made, the amount due will not increase in that assessment date, but may decrease if assessed as lower. It will therefore be important that applications for payment are submitted before each assessment date, and we will discuss this further later. The approach to compensation events has also changed in the main form. Additional compensation events can now be included in the contract data on agreement by both parties. In addition, the concept of a dividing date has been introduced for when a compensation event is assessed. And again, we will explain this in more detail later. The service manager or project manager also has a right to request a quotation for a proposed instruction. This is an interesting change and one which we'll discuss later, as it does have a bearing on compensation events and potential additional costs incurred by a contractor or consultant. Other tweaks to the main forms include, rather than indemnities, the NEC4 making the parties liable for costs. This is perhaps intended to soften the relevant clauses. The early warning regime has been upgraded and is now more proactive rather than reactive, showing the NEC4 promoting good project management. The insurance requirements have changed in the main forms. Any public policy must now include a cross-liability clause so that the insurance applies to both parties separately. This should be discussed with your broker before entering into the contract. The final general amendments are to the dispute resolution provisions. The NEC4 includes a process for parties to refer disputes to senior representatives for resolution, and that resolution is to take place over a 3-week period. However, where the Construction Act applies, this will the reference to senior representatives only is when the parties agree, because under the Construction Act you cannot prevent a party adjudicating if they so wish. Now back to Will.
Thanks, James. So I'm now going to focus on the NEC4 PSC. The structure of the NEC4 PSC is very similar to that of the NEC3 PSC, with two notable changes. Firstly, the payment options are different. There is no longer an option for payment on a time charge basis, the old option E. This has been replaced by the cost reimbursable option. In addition, the term option, option G, that's been removed on the basis that for a term contract, the term services contract should be used. In addition, the schedule of cost components and the shorter schedule of cost components is now included. This reflects the inclusion of the principle of defined cost in order to align the PSC with the ECC, and I will explore this further shortly. This amended contents page emphasises the limited changes which have been made to the NEC3 PSC to create the new NEC4 form. James has already discussed some of these changes, such as secondary option X10, information modelling or BIM, and I'm going to explore other significant changes to Core Clause 8, liability and insurance, and option X8, undertakings to others shortly. Other changes such as Core Clause 2, the consultant's main responsibilities, and secondary options X11, termination, and X12, collaboration, are merely changes in structure and terminology, and therefore, in my view, have no real substantive effect on the PSC. Note, smack bang in the middle of the screen, that the parent company guarantee secondary option X4 now provides that a guarantee is provided by the ultimate holding company. That's unless an alternative guarantor is accepted. So this will need to be managed. So as the contents page demonstrated, the key structure of NEC4 PSC is very similar to the NEC3 version. Similarly, the fundamental principles which underpin the NEC3 PSC also underpin the NEC4 form. Duty of care remains the same. The consultant's obligation is to use the skill and care normally used by professionals providing services similar to the service. The project management regime is almost identical. For example, the spirit of mutual trust and cooperation remains, and early warning notices are still required. In addition, the detailed and administrative program obligations have not changed. Moreover, the consultant's only right to additional payment and extension of time is still under the compensation event procedure. Adjudication and the service of a notice of dissatisfaction remain a condition precedent to referral of a dispute to the tribunal. As with the NEC3 PSC, the NEC4 PSC remains administrative, much more than any other typical consultancy appointment. We say this regularly, but consultants still need to ensure that they go into the PSC with their eyes open and ready to work the contract. The NEC4 PSC is not a contract to be left in the drawer. I'm now going to look at, in some detail, some of the key changes to the PSC. Starting with the new important role, that of the service manager. It's the service manager who now effectively administers the contract on the employer's behalf. The service manager, a new role, It's very similar to that of the project manager under the ECC, and it's central to the operation of the PSC. The service manager is required to act in the spirit of mutual trust and cooperation. It gives notices and instructions under the contract, accepts programs, assesses payments and compensation events. This is an obvious key change to how the PSC operates and will need to be managed carefully. It's a change, in my opinion, that will have a direct impact on the approach and conduct of the parties under the PSC. And generally, I have a number of queries of how it's going to operate in a services contract. For example, it's possible that the service manager may, in fact, end up just being the client. The liability position under the PSC has changed quite a bit. It's become more complicated, and to be frank, I think it's to the consultant's detriment. Clause 20.3 of the PSC limits the consultant liability for defects to where it has failed to exercise the required level of skill and care. This is a positive, but as with the definition of defect, this does not mean that the duty of care in the PSC now applies to all obligations under the PSC. We do, however, expect clause 20.3 to be commonly deleted or amended by clients. The approach in 20.3 is consistent with the approach taken in the ECC secondary option X15, the contractor's design. This formally stated that the contractor was not liable for defects due to design if they proved they used skill and care to comply with the works information. The NEC4 ECC approach, which no longer refers to the works information and does not shift the burden of proof to the contractor, should provide greater protection against fitness for purpose arising under the ECC. This in turn will provide some comfort for consultants appointed by contractors under the ECC if option X15 is included. That said, the new PSC does expose the consultant to additional risk and liability than under its predecessor. Firstly, whilst the NEC3 form required the consultant to indemnify the client against any infringement of the rights of others, under the NEC4 PSC, a number of risks are expressed as consultant liabilities. Consultants' liabilities include costs incurred by the client as a result of failure to exercise the consultant's duty of care and death or personal injury to the consultant's employees. These are reasonable risks for the consultant to bear. In addition, any claims and proceedings from others and costs payable to them as a result of the consultant providing the services is a consultant liability. Providing the service means to do everything necessary to complete the services in accordance with the contract. Risk is not a consultant's liability if it is a client liability. Client liabilities in clause 80 includes claims which are an unavoidable result of the service or which are caused by third parties employed by the client or by the client themselves. So what does this mean? It means that the consultant bears the risk of all avoidable claims as a result of the services, even if it is complied with the contract, and of claims which are caused by third parties other than those employed by the client, so a subcontractor or a member of the public. This is a much wider liability than arose under the NEC3 PSC. The consultant must pay any cost which the client is liable to pay as a result of a consultant liability. The amount due, though, will depend on any additional limits of liability in option X18 in respect of indirect and consequential loss and defects found after the defects date. Sadly, NEC4 PSC does not include clause 82.2 of the NEC3 PSC, which was a shorter net contribution clause. The client's right to recover costs as a result of a consultant liability is reduced, though, to the extent that an event for which the client is liable contributed to such costs. But this has a much more limited effect than the old clause 82.2. For example, if the costs are jointly caused by a subcontractor or a member of the public, it will have no effect. So, in our view, this is unfortunate drafting. The payment regime under NEC4 PSC has changed. It's become a lot more administrative and more complicated. Under the NEC3, the consultant simply submitted an invoice, which was the payment notice under the Construction Act, with the final date for payment being 21 days after the invoice was submitted. Now, under the NEC4 form, the consultant is required to submit an application for payment before the assessment date. The service manager then certifies payment within 1 week of the assessment date, with the service manager's certificate being the payment notice under the Construction Act. The consultant must then also submit an invoice within 1 week of the service manager's certificate in order to be paid. Failure to submit an invoice will now delay the final date for payment, and this is now the later of 14 days from the application date and 7 days from the submission of an invoice. This means that the consultant has much less control over the payment process, as the service manager gets 2 bites of the cherry to say that the consultant is going to be paid less, the certificate and the payment notice. The payment process is also very administrative and more complicated. Although this is not uncommon in bespoke appointments, this is a standard form, so one might expect it to be a bit more reasonable. NEC4 also takes a different approach to valuing sums due to the consultant. As I mentioned, there's no longer an option for payment to be on a time charge basis, as was the position under NEC3 option C and E. Under the NEC4 PSC, payment under option C and E is based on defined cost. Defined cost is also used to assess compensation events under all options. Now, some of you will be familiar with the principle of defined costs, as it was included in the NEC4 ECC. In option A, defined cost for the purpose of compensation events means the cost of components in the short schedule of cost components. In option C and E, the full schedule of cost components is used to determine defined cost. And disallowed cost is deducted from those costs. Disallowed costs includes, amongst other things, costs which are not justified by the consultant's accounts and records, the cost of correcting defects after completion, and the costs of correcting defects caused by not complying with a constraint in the scope. The concept of disallowed costs now gives the employer grounds to deduct sums from those claimed by the consultant, which may otherwise have been recoverable. For example, the requirement that the costs are justified is quite wide. There is also a risk that, as we have seen with the NEC4 ECC, clients through Z clauses will widen the scope of disallowed costs to further limit the sums recoverable. There's also a process for finally assessing defined cost under option C and E, and a requirement to maintain records, which is a further administrative burden on the consultant. So whilst this makes the PSC more closely aligned with ECC, it clearly requires a consultant to take a very, very different approach to applying for payment. Some consultants have expressed a real concern about this. The main concern is having to disclose certain information, such as the relationship between their fees and the sum paid to staff, as this information has traditionally been confidential. Generally, the NEC4 PSC takes, in my view, a much more contractor-style approach to payment than under a typical professional services contract. So quickly moving on to changes in relation to liability to third parties. So firstly, option X8 of the NEC4 PSC, undertakings to others, requires the consultant to provide any open speech marks undertaking, close speech marks, to a third party which is included in the scope, rather than simply collateral warranty agreements. Contract data will set out those undertakings, set out who those undertakings must be provided to. If option X8 applies, it will be important, obviously, to limit the individuals or classes listed in the contract data and to review the required form very carefully, as any undertaking provided will expose the consultant to additional liability or potential additional liability. In addition, secondary option Y UK3 of the NEC4 PSC now allows classes of beneficiary identified, again in the contract data, to be granted the right to enforce the terms of the PSC in the contract data. As with any appointment, the identity and classes of beneficiaries should be limited if Y UK3 applies. Rather than simply listing the terms in the contract data, a preferred approach would be to refer to a third-party rights schedule, which sets out the clauses the beneficiary can enforce, and contains an equivalent rights of defence clause, making clear that the consultant's liability to the beneficiary is limited to that which arises to the client. So look out for third-party rights schedules referred to in the contract data. The position under NEC4 PSC has changed fairly significantly in relation to a few other areas, which I'll wrap up on one slide: subcontracting, insurance, and termination. So acceptance is now required before appointing any subconsultant under clause 23.2. This is not unusual, but if a subcontractor is appointed for substantial work before the process of acceptance, this is now a ground for termination. The NEC4 PSC also includes additional insurance obligations in clause 84, including requiring a certificate signed by the insurer or broker to be submitted before the starting date, after the defects date, and on each renewal of the policy. If they're not provided, the client can take the drastic steps of taking out his own policy and recovering the cost from the consultant. It's unlikely to happen, but nevertheless, it's important that required certificates are provided. In addition, a consultant is required to take out any additional insurance included in the contract data. Client is required to take out the insurance stated in the contract data also, but I think it will be rare for the client to agree to take out any insurance in the PSC. I see this more commonly done in construction contracts rather than a services appointment. Another risk under the NEC4 PSC for consultants is that the grounds for the client to terminate have widened significantly. They now include a substantial failure by the consultant to comply with its obligations, and the consultant substantially hindering others or breaching health and safety regulations. Timescales have also changed to the consultant's detriment. In addition, the consultant's right to terminate for non-payment has been limited so that the non-payment must now continue for 13 weeks, not 8 weeks, although following termination for non-payment, as well as for insolvency or client default, the consultant is now entitled to the fee percentage of any of the prices which are unpaid. Yeah, obviously, termination is a significant issue. It doesn't arise often, but this new approach will need to be managed under the NEC4 PSC. James.
So that was a update on the PSC, and we are now going to look at the ECC. In terms of the layout, as we've already discussed, the basic structure of the ECC has not changed as set out on this slide. What is new is there are a number of new clauses and secondary option clauses which have been introduced to reflect market practice and to provide consistency. This comes about from the NEC's review of the operation of NEC3 and looking to improve it for a wider market. As set out on this slide, one of the changes is changes in terminology used. For example, employer is now the client. These changes are fairly self-explanatory, and this slide sets them out for your reference. Proactive risk management is at the heart of the NEC philosophy, and at the core of this is the early warning regime. This has been upgraded and is now more proactive than reactive. Within 1 week of the starting date, the first early warning register must now be prepared by the project manager, and an early warning meeting must be held within 2 weeks of the starting date. Further early warning meetings must be held at the interval stated in the contract data, rather than only one in response to an early warning notice. And this is perhaps the best example of the promotion of good project management. While the risk register has no substantive impact on the allocation of risk between the parties, failure to give warning of an expensive compensation event could impact adversely on the later assessment of that event after it has been notified. As we mentioned, essential ethos of the suite and good project management is the need for clear and effective communication. This impacts on matters such as the identification of management at risk, disputes, and time. The relevant core clauses for time remains in section 3. There is no change to the provisions for starting, completion, and key dates. It remains part of the project manager's duties to decide the date of completion and to certify within 1 week of completion. Clause 31 contains the provisions for the programme. The accepted programme is defined as the programme identified in the contract data or is the latest programme accepted by the project manager. It remains that the accepted programme has contractual effect and it plays a significant role in the assessment of some compensation events. Therefore, the provision remains that if a programme is not identified in the contract data, it is for the contractor to submit a first programme to the project manager for acceptance. That programme is to be submitted within the period stated in the contract data. In this respect, Part 2 of the contract data is where any programme is identified, and if not, Part 1 of the contract data is where the period of time for the contractor to submit the first programme is identified. If the contractor does not submit a first programme and there is no programme identified in the contract data, then as a new provision under clause 50.5, 25% of the work done to date can be retained in assessments of the amount due until a compliant first programme is submitted. This is to encourage the contractor to ensure that a first programme is submitted. So what is a compliant programme? Clause 31.2 sets out what the contractor must show on each programme submitted for acceptance. Aside from the general language change of scope from works information, these requirements remain the same, apart from the new addition that the submitted programme is to be in the form stated in the scope. Therefore, when considering the contractual documents, it is important to verify and have included in the scope the required format. This will allow you to ensure compliance in the first programme and any subsequent revisions, as well as the more obvious point that it is a format that your project managers are comfortable with completing. A further new and important addition is in respect of deemed acceptance of the programme. Under clause 31.3 in NEC3, the project manager had 2 weeks to either accept a submitted programme or not accept it for one of 4 reasons. However, there was nothing that dealt with the project manager's failure to respond other than the potential that it was a compensation event under clause 60.16. This is now addressed in NEC4. If the project manager does not respond to a submitted programme within 2 weeks, then the contractor may notify the project manager of that failure. If the failure continues for a further week after the contractor's notice, the submitted programme is treated as accepted. Aside from the fact this means no more 3-week holidays for project managers, it is interesting to note that a programme can be deemed to be accepted on the words of NEC4 even if it doesn't comply with the requirements of what it should contain under 31.2. In this regard, a deficient but deemed accepted programme could impact on the operation of other clauses that rely on the accepted programme, including the assessment of compensation events. An inability for the project manager to assess compensation events could give rise to further disputes and complexity, which takes the focus away from doing the job. Therefore, it is important that the project manager responds within these 2 weeks to avoid such risks. It should be noted that if the contractor does not notify the project manager of the initial failure to respond within 2 weeks, then the programme is not deemed to be accepted. Clause 32 deals with the revisions to the programme. 32.1 states the further information the contractor must show on each revised programme. Interestingly, this no longer includes the effects of implemented compensation events and of notified early warnings. It is unclear if this should form part of the actual progress achieved section of the revised programme, and this is an example of a change that will become clearer as the use of the contract grows. Under clause 32.2, it remains that the contractor submits a revised programme to the project manager for acceptance within the period for reply after being instructed to do so, when the contractor chooses, but in any case at no longer interval than that stated in the contract data. However, nothing has been added as a stick to force a contractor to submit a revised programme, as the financial penalty under clause 50.5 is only in respect of the first programme. The final change under time I want to raise is in respect of acceleration, which is a more consensual approach than under NEC3, and allows a proactive and forward-looking contractor the opportunity to make proposals to speed up a project. This not only can benefit a project, but can assist in building long-term trust and relationships with the ultimate client. It is now open to both the contractor and project manager to propose an acceleration. When the contractor and the project manager are prepared to consider the change, the project manager instructs the contractor to provide a quotation, stating changes to the key dates to be included. But there are now time limits. The quotation is to be submitted within 3 weeks of the instruction, and the project manager replies within 3 weeks on receipt of the quotation. When a quotation for an acceleration is accepted, the project manager changes the prices, key dates and completion dates accordingly and accepts the revised programme submitted by the contractor with the quotation. I'm now going to look at changes to the compensation event procedure in the ECC. There are 2 new compensation events added to the core clauses. Firstly, under 60.120, it is now a compensation event if the project manager notifies the contractor that a quotation for a proposed instruction is not accepted. This relates to the new clause 65 in respect of proposed instructions, and so entitles a contractor to recover costs of preparing quotations for proposed instructions that are not accepted. The procedure for the proposed instructions is set out on the slide. It should be noted that unlike the deemed acceptance of a program, if the project manager does not reply to the quotation within the time allowed, the quotation is not deemed to be accepted. However, it remains under clause 60.16 that it is a compensation event if the project manager does not reply to a communication from the contractor within the period required by the contract. If the quotation is not accepted, then the project manager may notify the proposed instruction as a compensation event and instruct a quotation for that. The second new core clause for compensation events is an express reference to specific and agreed compensation events stated in the contract date of Part 1. This allows the parties to consider risk related to a specific job and, where appropriate, to attempt to negotiate the inclusion of such risk as compensation events into the contract. This gives a focused approach to specific risks, including in respect of the contractual matrices between all parties, including consultants, and may avoid the need for excessive Z clauses. There is now a slight change to the procedure for notifying compensation events. Where a compensation event arises from the project manager or supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision, the project manager notifies the contractor of the compensation event at that time and includes in the notification an instruction to the contractors to submit a quotation. The exceptions to this are if the event arises from the fault of the contractor or the event has no effect on defined cost, completion, or meeting a key date. Clause 61.3 still governs notifications by the contractor of an event which has happened or is expected to happen as a compensation event, and which the contractor believes is a compensation event which the project manager has not notified. In place of the 8-week period to notify being aware of the event, there is now an 8-week period to notify only an event that has happened. It is not clear what the notification period is now for an event that is expected to happen. Presumably, time only starts to run when the event happens, but it is our view that it's best practice to notify events that are expected to happen promptly, so that it is on the radar of the parties and consideration can be given as to any instructions or acceleration that could assist in avoiding the event happening. In addition, failure to notify within the 8-week period has the same result as before: no change to the prices, completion date, or key date. The exception to this is no longer those events that the project manager should have notified but did not. When assessing compensation events, there is now a dividing date. For compensation events that arise from the project manager or supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision, the dividing date is the date of that communication. For other compensation events, the dividing date is the date of notification of the compensation event. This is important for considering actual against forecast defined cost in clause 63.1 and identifying the relevant accepted program for considering any delay to the completion date caused by a compensation event under clause 63.5. By the introduction of a dividing date, a contractor should closely monitor progress and submit revised programs for acceptance as necessary. Any delay in doing so may give rise to inadequate assessments of delay by the project manager, as he or she is basing the impact of a compensation event on a program that may be out of date. In relation to contractor's design, under the NEC3, the contractor would likely be subject to an uninsurable fitness for purpose obligation, unless X15 was incorporated into the contract. So a reference to option X15 in the first entry of the contract data should therefore be one of the first points for the contractor to check. Where option X15 is incorporated, it no longer requires the contractor to prove that it has used reasonable skill and care to ensure that its design complies with the work's information. This unreversal of the burden of proof such that the normal rule applies, that it is for the claimant to prove negligence or breach, must be seen as a positive change for contractors, given the difficulty of building a positive case of compliance. As regards professional indemnity insurance, clause X15.5 provides that the contractor must provide insurance in the minimum amount it says in the contract data from the start date until the end of period stated in the contract data, which will typically be 12 years from completion. However, what may need to be added is a Z clause that deals with any adjustment that can be made to this provision if, for example, premium rates increase by such an extent it is no longer financially viable for the contractor to take out such insurance. As regards payment, it is now a requirement under 50.2 for the contractor to submit an application for payment. If the contractor fails to do so, the amount due is the lesser of the amount assessed by the project manager to be due and the amount due at the previous assessment date. As such, the amount due will either be zero or a negative amount, which must be paid by the contractor. This is obviously a compelling incentive for the contractor to submit an application for payment if one is needed. There is a new provision in clause 53 stating that the project manager must make an assessment to the final amount due and certify a final payment no later than 4 weeks after the supervisor issues the defect certificate or 13 weeks after the project manager issues a termination certificate. The final payment is to be made within 3 weeks of the assessment or within the period stated in the contract data. There is a default procedure for the contractor to make its own assessment if the project manager does not make an assessment within the time allowed, and this amount becomes payable if it is agreed by the project manager. That assessment is conclusive evidence of the final amount due unless a party refers the matter to a disputes procedure board within the time limits prescribed in clause 53. In options C to E, there is now a main option clause which prescribes the procedure for the finalisation of a defined cost. The contractor must first notify the project manager when part of defined cost has been finalised and make available for the project manager records necessary to demonstrate that it has been correctly assessed. Project manager must then review the records and no later than 13 weeks after the notification either accept that part of the defined cost is correct or notify the contractor that records are needed or notify any errors. The contractor must provide further records within 4 weeks or correct the errors within 4 weeks. Project manager then has another 4 weeks to accept the cost is correct or notify the contractor of the correct assessment of that part of the defined cost. If the project manager does not notify a decision on that part of the defined cost within this period, the contractor's assessment is treated as being correct. However, it should be noted that the dispute resolution provisions gives the project manager a get out of jail card which applies to its actions or inactions. Of course, there is no corresponding get out of jail card for the contractor. There are similar changes to the schedule of cost components under options A and B, which also need to be considered if you are using these options, including reverting to a single fee percentage, so there is no differentiation as there was under NEC3 between direct fee percentage and the subcontracted fee percentage. As we are closely approaching the hour mark, we have a few more slides on liabilities insurance. The main changes are set out on these slides, so we don't need to go through in any real detail, but obviously must be considered when entering into the ECC. This slide covers the contractor's proposal, which we have touched on before, and again is part of trying to get the contractor to be more proactive and forward the philosophy of the NEC4. And as set out on this slide, there are some other new provisions for you to note, but again, we will not be going into these in detail today.
Thanks, James. So back to me to conclude in relation to the PSC. In relation to the PSC, the amendment in clause 20.3 in relation to limiting the consultant's liability for defects to where it has failed to exercise the required level of skill and care is positive, as is new option X10 in relation to BIM. The PSS is also a welcomed addition to the family. But my view is that the amendments to the PSC have made the form more onerous for consultants, and in particular bring in contractor type provisions. Liability for third-party claims, no net contribution clause, a more administratively demanding payment regime, ultimate parent company guarantee, the requirement to submit applications and invoices, disallowed costs. There are others. Were these changes absolutely necessary? I don't think so. Do they make the form more onerous? Absolutely. The introduction of the service manager might be helpful for major schemes, but do we really need one for a typical design or other services commission? It's only going to add to the cost of using NEC4, a further cost in fact, given that consultants typically price an NEC contract higher than others because of the administrative burden arising out of it. And if you don't, and it's easy for me to say this, you should be pricing an NEC4 project higher. So a change for the good, the NEC4 PSC, from a consultant's perspective, probably not. The form is more administratively demanding and certainly more onerous.
On the other hand, we think the ECC has some more positive changes that strengthen the operation of this form. In particular, deemed acceptance of program is very useful for contractors to manage their own workflow. The provisions for the assessment of the final amount due and for options C, D and E final defined costs are also useful. Having the burden of proof unreversed for design liability under X15 is a key change, and the reversion to a single fee percentage and simplified administration of the short schedule of cost components is a positive. There are new options to reflect current practice and common employer-client requirements in relation to collateral warranties, information modelling, etc., so that the changes aren't that great in the grand scheme, but are for NEC. That said, we still expect the use of a significant number of Z clauses to continue with the ECC, NEC4, and this may impact on the efficacy of the proposed changes. So, as with the PSC, our advice is be proactive and ensure you allow adequate management resource given the administratively demanding and expensive requirements of NEC4, and whatever you do, do not leave it in the drawer. Will and I hope you found this webinar useful. As Will mentioned, and given the time, we will follow up on any questions we have received during the course of the webinar. And of course, if anyone has any other queries, please do not hesitate to contact me or Will. Thank you once again for listening to us today, and have a good afternoon.